Hendriks, and I'm an attorney, practice at SchoemanLaw, based in Cape Town and Paul. And today we'll be discussing mutual separation agreements. So, in the complex realm of employment relationships, disputes and dissatisfactions can arise, creating the need for amicable resolution. Among the strategies for addressing these challenges, the mutual separation agreement, MSA, has emerged as a popular alternative to conventional termination or litigation. By facilitating a collaborative negotiated exit, MSAs offer a balanced solution for both employers and employees. I think it's important for us, before diving into this conversation, is that from the outset we need to understand what a mutual separation agreement is. A mutual separation agreement, an MSA, often referred to as a separation agreement or a termination of employment agreement, is a formal contract in which an employer and employee mutually agree to end the employment relationship. So unlike a unilateral termination or dismissals, MSAs are based on voluntary consent and typically outline the termination date and agreed upon financial settlements, including notice pay or ex gratia payments. There are confidentiality clauses to safeguard reputations. There are a full and final settlement, so there will be a full and final settlement clause ensuring that no further claims arise from the employment relationship. And MSAs are always formalized in writing, signed by both parties and witnesses, ensuring their binding nature. So, why MSA? What are the benefits? There are a number of benefits, namely 5, that provide you with certainty and finality. So litigation outcomes are inherently unpredictable, and even with a strong case, MSAs eliminate uncertainty by offering a guaranteed resolution that both parties can trust. Number 2 is that it's the confidentiality and reputation management. So legal disputes are public in the public forums like the CCMA and Labour Court can tarnish reputations as they are available to the public. With MSAs, with their confidentiality clauses, it shields both parties from unnecessary scrutiny. Okay. Then the third one is that it's time and cost efficient. So litigation can span months or years, accompanied by significant legal fees. MSAs, conversely, can be concluded in days, saving time and resources for all involved. Relationship preservation. So the collaborative nature of MSA fosters a goodwill, reducing animosity and preserving professional relationships. So in this way, the parties can live on good terms and no bad terms are created between the parties. And then your first one is that it's flexible and you can be creative with an MSA. So the MSA allows tailored solutions that suit both parties, such as defining transition timelines or customizing settlement terms to accommodate specific needs. Although there are benefits, there can be challenges and resistance that one can experience from a MSA. So despite the advantages, MSAs can encounter resistance due to matters of principle, and this we essentially refer to employers or employees may prefer litigation to uphold values such as zero tolerance for misconduct or exposing systematic work-based issues. Number 2 is that there are precedent concerns, so employers may seek to set a disciplinary standard that discourages similar behavior among staff. Confidence in merits. This applies to both employers and employees. The strong belief in one's case can drive parties to pursue formal resolution over settlement. And then lastly, we're dealing with the fear of misrepresentation. So proposing an MSA might be seen as an admission of guilt or lack of grounds for termination. this would be applied to both employer and employee. These challenges necessitate clear communication and careful negotiation to ensure that the MSA are seen as voluntary and non-coerced. There are also aspects such as ethical considerations and misuse that I think it's important that we understand, that you be made aware of, is that while MSAs can foster ethical resolutions, they have also been exploited as vehicles for concealment. So high-profile cases involving golden handshakes and the confidentiality clauses have occasionally masked corruption or misconduct, and the courts can nullify MSAs entered in bad faith, emphasizing the need for transparency and adherence to public policy. So I think this is an important part or understanding of the MSA, in that we need to ensure that it is done correctly. And in terms of the practical guidelines, employers and employees considering an MSA should approach discussions with these principles. So the discussions need to always be on a without prejudice basis. So discussions are off the record, fostering an open dialogue without fear or legal repercussions. MSAs always need to ensure that there's clarity, ensure that the terms are precise, addressing payment timelines, termination dates and confidentiality obligations, and it's always recommended that you seek legal advice. So consulting with a legal consultant helps identify risks and ensure compliance with South African labour laws. But in conclusion, I think it is fair to say that mutual separation agreements offer a pragmatic, amicable alternative to traditional employment termination methods. So by focusing on collaboration and mutual respect, MSA provides certainty, preserving relationships and minimizing reputational and financial risks. However, the implementation requires care. So there needs to be transparency, there needs to be an ethical intent. Clear communication are essential to avoid disputes or occasions of coercion. So when approached thoughtfully, MSAs can transform a potential continuous exit into a dignified and mutual beneficial resolution. Thank you for joining me. Please like, comment and share in the box below. Please don't forget to subscribe to our YouTube channel and newsletter, and for information please visit our website at www.SchoemanLaw.co.za.